Members, we've got a quorum. I now call the meeting to order. Please invite the officials to join us. Good morning. I'd like to welcome representatives from the government. I would like to, first of all, invite the government to introduce the subject, and that is Toys and Children's Product Safety, Additional Safety Standards or Requirements Regulation, Toys and Children's Product Safety Regulation Repeal Regulation, and Toys and Children's Product Safety Amendment Ordinance 2013 Commencement Notice. And then I'll see if members have any questions to put to the administration. Mrs. Zhang. Thank you, Chairman. Let me introduce the background. In December 2013, the Toys and Children's Product Safety Amendment Ordinance was enacted, and through the enacted ordinance, we expanded the definition of toys and children's product to cover products that are intended to facilitate the feeding, hygiene, relaxation, sleep, sucking, or teething of a child under 4 years of age. And also it enabled us to make other amendments to the ordinance, and also to make regulations to control the concentration of 6 types of phthalate in certain toys and children's products, including DHP, DBP, BBP, DIMP, DIDP, and DNOP, which are chemicals commonly added to the plastic products to improve their flexibility and durability. They have very low acute oral toxicity in humans, but chronic exposure to these chemicals may result in adverse effects to the liver and the reproductive and developmental systems. As these products can be used by children for a prolonged period, many economies have make certain regulations to regulate the concentration limits, and they include the EU, the United States, Canada, and Singapore. And we have to make sure that our regulatory regime is on par with these economies, so that we will not become a dumping ground of substandard products. When the amendment ordinance was scrutinized, we explained how we are going to regulate the 6 types of phthalates in a framework. And now we have regulate the regulations. The Bills Committee raised a few concerns, and also submissions from the business sector and consumers groups were received, and we have collated the views, which some of them have been taken into account in the current exercise. For example, whether packaging will be regulated, and the answer is no. And also in the calculation of the concentration limits with respect to the phthalates and also the plastic part of the product, any parts that are not out of reach to a child will be discounted. And we also said that we will allow sufficient time for the sector to cope, to adjust and cope. And that's why we want to set the commencement date at the 1st of July to enable the sector more time to adapt. So apart from the regulation of the chemicals, we also take the opportunity to regulate, to put the requirements in 424B into the new regulation. So in the same set of regulation, you can see all the relevant requirements, whether it's for the chemical filters or the other safety requirements. So if members are agreeable, the commencement day is the 1st of July 2014. And also the new regulation would also commence on the same day. That's all for my introduction, Chairman. Let me declare my interest. I'm a shareholder and a director of a toy factory. Any declaration of interest from members? Andrew, what about your grandchild, who is very fond of playing with toys? Well, not yet. Not yet. And Mr. Wong? I certainly heed the advice of Mr. Wong Ting Kwong. In calculating the pesticides amount, as I see it, it's not very clear. If we have a toy, there are many parts. Say it's a doll, hair, torso, limbs, which are made of different plastic materials. So would you count the parts with plasticizers or the entire doll? Because the doll may be made of soft plastic with plasticizer, but the torso isn't. So do you take into account the whole doll, or that's just the part with plasticizers? We have to find out whether it's type 1 plasticizer or type 2. There are 6. And in Europe and the US, they are regulated differently. If DBP, BBP, and DEHP, among the 6, would be calculated with respect to the whole toy. The total amount, content, the total plastic is the denominator, and you will look at the amount of plasticizers, and then we'll exclude parts that cannot be touched, for example, internal wiring and so on. But for type 2, and in the US, Canada, and Europe, it's the same. It's whether it can be put into the mouth. If it can be put into the mouth, then the entire small toy will be taken into account. So if the toy can only be partially put into the mouth, then that part will be counted. So you don't look at the parts. You look at the toy as a whole. Well, if it's part 1, plasticizer, then it's on the whole toy basis. For part 2, it depends on whether it can be put into the mouth. And the definition is the same, and the limits are the same. When 5 mm or smaller, the US and Canada also adopt this 5 mm standard. All right? Questions? If there are no questions, we can proceed to the cross by cross, if members agree. Let's look at the ordinance first. Alice, a legal advisor, has something to raise here. We are now looking at LN 17, which will take the place of Toys and Children's Product Safety Regulation. That is to say, for CAP 424B. So when the government refers to the new legislation, if there's anything which is different from the existing legislation, please remind us. As for questions raised by the Legal Service Division, please also raise the relevant points as we go over the cross-by-cross exercise. Please also refer to CP 21017-13-14-04. LM 17 comes in a few parts. And part 1, part 2, and part 3. And also commencement day, part 1. We will put the commencement date as the 1st of July, like the ordinance, the amendment, the new ordinance, amendment ordinance. Interpretation. Company is just a definition under the company's ordinance. And also, when we proceed to 7, 8, 13, and 14, we would tell you about what are going to be excluded, and the use, so-called use, and also improper use by children will be referred to. And now we have different types, 2 types of plasticizers, DD, and the 6 products. And the full name is set out DHP, DBP, BBP, DIMP, DIDP, and DNOP. Part 2 and Part 3 regulates children's product. They have different regulatory requirements. But to put it simply, we will refer to these plasticizers as type 1, class 1 or class 2. Any question? If not, please move on. After the definition, bracket 2, we're talking about 8 and 14.
We'll then discuss whether or not a toy product can be put into the mouth of a child at the age of 4 or below, or whether or not a certain product can be fully put into the mouth of such a child. Some European jurisdictions use this yardstick to measure the product, that is, how to put the product into the mouth of the child. So for the definition of phthalates, we've already taken reference from the practice of European and American jurisdictions. In A, either the product is very small, the dimensions are smaller than 5 cm, then we take it that the whole product can be put into the mouth. And in certain cases, the size is not less than 5 cm, then we'll use whether or not reasonably foreseeable manner will allow such a product to be put into the mouth of a child and be mouthed. Mouthing is very important because for many jurisdictions, both mouthing and chewing are considered. So we have to consider the materials, the shape of the product, whether or not it is soft and very easy to be put into the mouth. So when it comes to clauses 8 and 14, we'll be using the definition. Then for bracket 4, we're actually taking reference from that. Members, any question about 2? No. So for 3, we're taking reference from 2. But is that the difference is that if not the whole toy can be put into the mouth and only part of the toy can be put into the mouth, then what do we mean by part? Well, by part we mean below 5 cm or in a reasonably foreseeable manner, the product can be put into the mouth of the child and be mouthed and chewed. Well, under the ordinance, in certain parts, there are also definitions about small parts. That is, this definition of 5 cm. That's my understanding. That is, in certain cases, the toy can be dismantled into loose parts with a certain degree of strength. So the two should be read together. Yes, we also refer to the practice of European and American jurisdictions and will try to cope with their practice. Members, any other comments? Alice? 4. 4 is to make it clearer about toys that can be inflated. That's about parts 2 and 3. For inflatable toys, how are we going to measure the 5 cm? We'll use the condition of not being inflated. Any questions? No? So Alice, please continue. Clause 3 is about applicability. Here you can see that you have A and B. First of all, for the principal ordinance, in Part A of the definition for toy, it is made clear that the product is for a child to play. And this will not cover B of the definition for toy, which is about packaging. So this regulation is not to regulate packaging. B the same. 2C1 is covered of the ordinance. That is about the children's toy for mouthing and so forth, but 2C2 is not covered. 2C2 is about packaging. So we can see that this ordinance and regulation are not related to packaging. Members, at another meeting, we mentioned that packaging should not be included. So now it's clear that the two are separated. Andrew, I have a question. In recent years, many parents give their children mobile phones, iPads, etc. And mobile phones are smaller than 5 cm. Well, and that is for the child to play with so that it will keep quiet and the child may put the product into its mouth. Well, it depends on whether or not phthalates are contained. Alice? Thank you, Chairman. Thank you, Mr. Leung. This ordinance is about toy products and will follow the definition for toy product. That is, the design is clearly intended for play. In other words, if the original use of the product is not for a child to play with, then it is not a toy. So that may be the duty of the parent and not the duty of the law. That is, not to allow a child to put such a product into its mouth. Legal advisor, any grey areas here? Mr. Chairman, perhaps I should give you some supplementary information first. For 3, about applicability or application, the ordinance is also mentioned. We've prepared a marked up copy which has been distributed to members. It's paper CB bracket 21016/1314 bracket 01. So if members can refer to that copy, on page 1 we have a definition for toy. That's on page 2 of the English version. Toy means a product or material that is designed or clearly intended for use in play by a child, or the packaging of that product or material. So an iPhone may not satisfy this definition. In other words, when in a supermarket, department store, or toy shop we buy a certain product, certain products are specified as toys, but there are other products like mobile phones which are not defined as toys, so will not be covered by this piece of legislation. So if a parent or an elderly person provides such a product to a child for playing, that's not a toy, and so will not be covered by this piece of legislation. Is that true, legal advisor? Yes, Chairman. As I said, in Section 3, the definition for toy, the definition follows the definition in the ordinance. That is the definition I just read out. That is, the product is designed or clearly intended for use in play by a child. Mr. Chairman, your legal advisor is correct. This ordinance regulates toys. A toy is designed or clearly intended for use in play by a child. Of course, in certain circumstances, toy manufacturers may design a false or mobile phone for playing purpose, but that a true iPhone will not be considered as a toy. Mr. Wong Ting Kwong? Mr. Chairman, there's a certain point that may not be directly related to this scrutiny exercise. I'd like to say that mobile phones and their accessories like plastic covers are also plasticized products or materials. So, Mr. Chairman, this piece of legislation aims at protecting the children. But what about other products which involve plasticized materials? Should phthalates be banned as well? If our main purpose is to protect the child, then apart from toys, in other pieces of legislation about phthalates, should we not have similar regulatory provisions so that we can more comprehensively protect our children. That is, we should not confine ourselves to toy products. Alice? In fact, when we drafted these legislations in the consultation exercise at the beginning, we tried to take reference from the advanced jurisdictions. We say we want to help or protect children. So what we're now proposing is already the practice of certain jurisdictions. Well, some jurisdictions may be regulating products totally irrelevant to children, like cosmetics. Anyway, for toys for children and products specially designated for children, they are covered. In other jurisdictions, their research projects did not just focus on children or their developmental problems. After prolonged experiments in their laboratories, they found that such products will adversely affect the liver, kidney, reproductive and developmental systems of animals. So they adopted such measures. As for the children's products that we are discussing now, only Turkey and one state in the United States regulate even shoes. But that practice is not a common practice globally because the whole EU and the other states of the USA are not adopting that practice. So we'll continue to closely monitor their experimental directions. Mr. Wong Ting Kwong? Well, Mr. Chairman, I support the proposed amendments. As for the question that I just posed, probably they cannot immediately look up other pieces of legislation. They can give us a written supplementary paper. What I mean is that apart from these plasticized materials, are there other materials that will be regulated for children's toys products under this amendment exercise? Well, apart from these 6 types of phthalates, there are a lot of opportunities for children to come into contact with them. As for other phthalates like PVC pipes for drainage purposes, they also have standards as far as I understand. But those standards are not as stringent as those for toys. As for the details and the differences in the 2 sets of standards, you've already requested a written reply. Well, yes, they should give us a written reply. It's very difficult for us to give us a reply today. I understand that there should be differences in standards because we should have more comprehensive regulation for children's products and toys products. But I'd like the Bureau to follow up on other products. Is our regulatory regime as stringent as that for toys and children's products? Can we draw a comparison between this amendment exercise and those regulatory provisions for other products? Well, if I understand you correctly, you're saying that we should be more stringent about this regulatory regime for toys and children's products, but that may not necessarily be applicable to other products. Oh, yes. Now, this is made very clear in the amendments. Packaging is not covered. And then in number 4, it's explained that Part 2 is about toys, and Part 3 is about children's products. Any questions? Please continue. So we move on to Part 2, that is about toys. There are 2 subparts. One is for the supply of toys, and another part about fowlets. Well, let's discuss the first division with number 5 and number 6. Number 5 and number 6, as your legal advisor and I said, it's under 424B about identification of labels and alerts and advisors. 424B is already included in this regulation.
So this provides at a glance provisions so that when you want to look up for requirements for toys, they're all here. Markings, we look at the toy, the packaging, and the label affixed to a toy, and also the document enclosed in the packaging. There must be suitable identification markings, the full name or trademark of the manufacturer, importer or supplier, and the address. These have already been regulated in the 424B, but that's an additional requirement, and that is under 51C. We have the word toy in Cap 424B. Under C, the label can be affixed to the packaging, but the label may also be affixed to the toy. We want to facilitate law enforcement agencies and the users. So we have expanded the scope to include a label affixed to a toy. The others are the same as those in Cap 424B. Mr. Wong, a question about 2A, bracket 2, bracket A, that is, if only the full name or trademark of the manufacturer is indicated, and then the address of the supplier is provided, and not the name of manufacturer and address of manufacturer, or name of supplier and address of supplier. Is it allowed to provide name of the manufacturer and address of supplier? I don't think so. It must be related. The connected person of the address of the connected person must be indicated under B. But you use the word or. So I can provide information on the supplier or the manufacturer, or well, it's either or one of the three. Yes, in respect of A, it's correct. You can provide the full name or trademark of the manufacturer, or the full name or trademark of the importer, or the supplier, those of the supplier. But between A and B, they are connected. The two are connected with N, the address in Hong Kong of that particular party. I don't think this is a new requirement. In the existing legislation, you have to give information on the wholesaler or retailer for the purpose of tracing the importer or the manufacturer. It's already done on the packaging. The trademark owner, the manufacturer. Some do not have the address of the manufacturer. My understanding is this. So for A, you choose either one, and you have to indicate B. It depends on which one you choose under A, the address of the party chosen. So is the sector clear about this? Certainly, it has been in use for years. Thank you. Please continue, Alice. Bracket 3. If it's a company, then the address is the register office in Hong Kong of that company. No change from the current CAP 424B. All right. Questions? Please continue. Section 6, bilingual warnings or cautions, is also in 424B. If there are warnings, for example, how to use, how to store the toy, if there are safety warnings, and you can find such warnings put on the packaging of the toy, on the toy itself, or in a label, or documents enclosed in the packaging of the toy. Then under bracket 2, the safety warning must be legible and must be in both the Chinese and English languages. And then under bracket 3, bracket 4, bracket 5, and bracket 6, the warning, safety warning, must be in a conspicuous position on the toy, and it must be securely affixed to the toy or the packaging. So they correspond to the other subsections, and they're already in 424B, except bracket 1, bracket C, and the reference to the toy there. Under 424B, the warning, the safety warning, must be or can be contained in a label affixed to the packaging of the toy. But we think a label affixed to the toy should also be allowed, so it's incorporated here. Apart from that, there's no change. Questions? If not, please move on. Division 2. Here we have some sections on phthalates. Two classes, class 1 and class 2, 3 in class 1, 3 in class 2. And this part is about toys. And that is for subsection 1, subdivision 1. Section 7 is about the regulation of class 1 phthalates in toys. If it contains class 1, is regulated, and under 7 bracket 2, the total weight of class 1 phthalates in the toy must not exceed 0.1% of the total weight of the plasticized materials in the toy. And 3 and 4 are about the excluded areas. For example, a component part that is not accessible will not be taken into account in the calculation of the total weight and in the calculation of the plasticized materials. And under bracket 4, the meaning of inaccessibility is explained. That is to say, a component part of a toy is inaccessible if the component part cannot come into contact with a child through reasonably foreseeable use of the toy. And what is a reasonably foreseeable use of the toy is in the interpretations section. And here we also cover foreseeable improper use. For example, the toy may be thrown about or chewed on. And here the limit is 0.1%. For exclusions, the US is the front runner. The EU does not allow this. We consider that parts that cannot be exposed or accessed, even if the toy is thrown about or chewed on. So here, that's why we have this formulation. Well, we did have a discussion on this, whether it should be calculated with reference to the whole toy or the components. Please continue. Subdivision 2, Class 2 phthalates, and the regulation of Class 2 phthalates in toys. Section 8 and Section 9 are relevant. Section 8 first. For Class 2, in other countries, they are not as stringently enforced as Class 2, because the adverse effects of Class 1 phthalates are more certain than those for Class 2. And we are here only regulating the toys capable of being placed into mouth. And we draw the line at 4 years of age. If a toy can be placed into the mouth of a child under 4 years of age, and it contains any Class 2 phthalate, then the 0.1% limit will apply. That is, the total weight of the Class 2 phthalates in the toy must not exceed 0.1% of the total weight of the plasticized materials in the toy. Likewise, like the case in Class 1 phthalates, a component part of the toy that is inaccessible is not to be taken into account. So if it's not accessible by a child or cannot be put into the mouth of a child under 4 years of age, it will not be taken into account. All right, next we look at the parts or partly placed into mouth. Yes, Section 9. If only a part of the toy can be placed into the mouth, then we would look at that part. If there are 2 parts, then we look at those 2 parts. Again, we exclude inaccessible component parts. Members, do you have any questions? Alice, please continue. That's the end of Part 2, toys. And now we are on Part 3. And Part 3 is on children's products. And the layout is the same as those sections for toys. We have 2 divisions. First, identification markings, and then Division 2, phthalates. In respect of identification markings for children's products, there are 2 sections, 10 and 11.
For Section 10, again is about children's product. The packaging of a children's product, a label securely affixed to a children's product, or the packaging of a children's product, or a document enclosed in the packaging of a children's product, and the information is the full name or trademark of the manufacturer, importer, or supplier of the children's product, or any other mark of the connected person that enables the person to be identified, and the address in Hong Kong of the connected person. And 10(1)(c) also carries the provision in 424B as we mentioned. Section 11 is the same as the foregoing provision. That's about bilingual warnings or cautions. These bilingual warnings or cautions can be included in those areas that I just mentioned. If there are such warnings or cautions, they must be legible and must be in both the English and Chinese languages. And if the safety warning is marked on the product, the warning must be in a conspicuous position on the product and marked on the packaging of the product in a conspicuous position on the packaging. And if the warning is contained in a document enclosed in the packaging, the warning must be in a conspicuous position on the document as well. So the provisions are the same as we mentioned. For Part 3, Division 2, it's about concentration of phthalates in children's products. Again, we have a few subdivisions. Section 12 makes it even clearer that this division is about certain children's products. That is, this division applies to a children's product that is intended to facilitating the feeding, hygiene, relaxation, sleep, sucking, or teething of a child under 4 years of age, and that contains any plasticized material. So we're following the practice in European and American jurisdictions. Any questions? No? So please continue. Subdivision 2 is the same as that for toys, that is for Class 1 phthalates. This is in Section 13. This section applies to a children's product that contains any Class 1 phthalate, and the total weight of the Class 1 phthalates in such a product must not exceed 0.1% of the total weight of the plasticized materials in the product. And in determining the total weight of Class 1 phthalates or the plasticized materials, a component part of the product that is inaccessible is not to be taken into account. Members, any questions? No? Alice, please continue. Subdivision 3 is about Class 2 phthalates. 3 types of phthalates here. This is about products capable of being entirely placed into the mouth of a child under 4 years of age, because just now we're talking of products that may not be placed into the mouth of the child. Again, we use the threshold of 0.1% of the total weight of the plasticized materials. Similarly, as this subdivision is about a product that can be put into the mouth of a child, a component part of the product that is inaccessible is not to be taken into account. Section 14 is different from the previous provision in that it is applicable to a product that is capable of being entirely placed into the mouth of the child. And Section 15 is about products capable of being partly placed into the mouth of a child under 4 years of age. So the practice is the same. In fact, the provisions follow the regulatory regime for Class 1 phthalates and Class 2 phthalates. Alice, please continue. I think we are now on the explanatory note. Yes, the explanatory note is to explain the commencement date, the definition, and in the main, the application of the regulation. It is mentioned here that Sections 5 and 6 apply to the identification markings. 11.3 is about children's products, and thereafter the regulation of phthalates. So that's basically the sequencing of the provisions. Perhaps I should, well, at this juncture, I'd like to invite the legal advisor who would like to offer some supplementary remarks. Mr. Chairman, I think the officials are about to come to this. This new regulation is to replace the existing 424B. Now, we went through the provisions just now. I'd like to draw members' attention to 2 points. Perhaps the officials can also do so. In the old Section 5, there are provisions about penalty. In the new regulation, there are no corresponding provisions on penalty. So perhaps the relevant officials can tell us about the penalty arrangements under the new regulation. Secondly, I'd like to invite the officials to explain to us the defense available. I did write to the administration to ask similar questions. Perhaps I should invite the officials to respond first. Then I think we need to go to the principal ordinance, which carries the penalty provisions. There are no penalty provisions in the regulation. So perhaps the administration can explain to us whether or not the absence of penalty in the regulation may cause readers to neglect the penalty in the ordinance. Well, just now your legal advisor asked, in this exercise, the original 424B is to be included in this new regulation, and we're proposing corresponding acts. In 2010, the principal ordinance was amended. At that time, in Section 8 of the principal ordinance, we added something. That is, if a person breaches the subsidiary legislation, then in accordance with Section 8, that constitutes an offense. So after that addition, we should have put the provisions in 424B deleted so as to make it tidier, to follow the penalty provision of the principal ordinance, as well as to follow the defense provisions in the principal ordinance. So we should have done that when we regulate phthalates. Of course, that exercise has taken longer than expected. That's why we're only doing that now. So there is a time lag here. What is the difference here? 424B originally said that if you don't do something, you commit an offense. And as your legal advisor said, that will attract a penalty. Now, the penalty and defense provisions will be the same as those under the principal ordinance. There's no big difference. for the defense provisions, the original 424B did not provide dedicated defenses. So if we use 424B to prosecute a person for not providing the proper identification markings, that person will not have the defense protection as is now provided under the amendment ordinance. So it will be 424(7). Yes. In the past, if we use 424B to prosecute the person concerned, in 424B there was no defense provision. So it really depends on whether or not the defense is available. Well, for 8.7, the official mentioned Section 8 in the principal ordinance. May I now refer you to page 6 of the Chinese version of the marked up copy of the amendment ordinance. There you have the amendments for Section 8. That is on page 6 of the English version. And then you also see Section 8.7. Well, 8.7 has not been amended. For penalty, the original 424B did not have a continuing offense. But that's in the principal ordinance. Depending on the actual circumstances, we have to examine whether or not it is a continuous act. So if you look at the whole principal ordinance, this continuing offense may also be applicable depending on the circumstances. Yes, you mean the penalty, the fine of $1,000? Yes, the fine of $1,000. Legal advisor, for the daily fine of $1,000, you can find it in Section 31(2) of the principal ordinance. The Legal Services Division wrote to the administration on this point. This can be found in paper 1017-01. At the end of that letter, we included the penalty under 31(2). In other words, after the amendments are enacted, the person prosecuted under 31(2) can be punished by the court at a daily fine of $1,000 if it is a continuing offense. But the original 424B does not carry that penalty. Well, there are only two differences between the two, as I mentioned. Legal advisor, is it all right? Thank you, Chairman. The reason for the change in policy as well as the legislative consequences have already been clearly explained by the administration just now. It depends on whether or not members would agree to accept those differences. I can also say that we issued another document to the government to ask them under the existing 424B and the amended 424B, which puts the provisions under the principal ordinance, the defense made available. For honest and mistaken belief. Now, the response from the administration has already been tabled today. I'll defer to Ms. Chan. Yes, thank you. Manda, the legal advisor asked us a question. In accordance with the regulation, that is 424B, whether or not the defense of honest and mistaken belief is still available. As mentioned by your legal advisor, under 424B, there's no dedicated defense. So, the defense of honest and mistaken belief should be available to the person charged under the ordinance. So, if the content is included into the ordinance, then the defense under 8.7 will also be available. That is, in future, whether a person will use a common law defense or put up a defense under 8.7, it will depend on which provision is applicable to the person charged. So, the defense protection for the person charged is not affected.
I think it's comprehensive, especially on the part related to continuous offense. But I don't know whether in the principal ordinance there's any requirement on callbacks. Alice? In the principal ordinance, whether it's continuous or not, the law enforcement agency had a few things to do, to ask for the products to be recalled and so on and so forth. So it's covered, but I don't see that in the ordinance. But there are such requirements. Dr. Helena Wong, I don't know whether this is the right time to ask this. Does the regulation regulate online activities or the supply of toys through the internet from a certain country whereby they don't have the same requirements, there's no marking on or safety markings requirements and so on and so forth? What kind of regulation is there? We're not talking about buying and selling on the net. Yes, I understand, but we are referring to the manufacturer, the importer, and the supplier have to comply with our requirements. And I'm referring in particular to the case of a supplier on the internet. Alice? The regulation doesn't really just regulate non-internet related activities. It's just that the scope may or may not be regulate a foreign supplier. If the supplier is a Hong Kong person and he sells to Hong Kong customers, then it's covered. If an individual approaches a foreign supplier and asks the foreign supplier to ship or to send over post some toys to the consumer, so it's an importer who is importing for his own use, then I don't think our laws can extend its applicability or application to something foreign. But if the supplier is in Hong Kong, he has imported some products, and then he sells those products either through the internet or sell them as a in a physical shop, then it will be regulated all the same. I think it's a real problem, very interesting, but it doesn't just apply to internet shopping. It's just like what we used to do, postal purchasing. And when you buy something through the postal means, and then the product is not up to certain standards, and if the product is for your own use and you don't sell the product to someone else, then the law doesn't really have anything to do with the standards. It's a question of public education, but I think it's outside the scope of the regulation, because the sale or the importation is not really related to Hong Kong. Well, my understanding is that if you sell these products in Hong Kong, it would be subject to Hong Kong law. If it's done outside Hong Kong, including transactions through the internet, it's going to be controversial, and it's already up to the court to decide. Sorry, I would like to ask the legal advisor to say something. I think the administration has already spelled out in very clear details the jurisdiction issue. Of course, the consumer should be responsible for his own behavior. So when we enforce this, is there going to be some loopholes? If someone buys something over on the internet, and you know that there's no national boundary on the internet. Say you buy something from a certain website, and through postal delivery, the products are imported in Hong Kong, and then he sells those products at Abu Street, and of course he's subject to the law. And the one who is going to be prosecuted is the one who sells the products here in Hong Kong, and not the supplier, foreign supplier. Is there any vicarious liability? Of course, if the supplier is in Hong Kong, there is liability. But we're not talking about loopholes here. We're talking about the jurisdiction and the application of local laws. We don't have, our laws don't have extraterritorial effect. If you order something from supplier outside Hong Kong, Hong Kong SAR government has no jurisdiction over that foreign supplier. But you import the products, and you also supply the products in Hong Kong, then you are subject to this regulation. Following on that question about vicarious liability, if you import and then the products, and then the products are sold by another person, will the liability be imposed on the importer as well? Both the supplier and the importer will be responsible, and the law enforcement agency, that is the Customs and Excise Department, will look at the case in question to see who has to shoulder a higher responsibility. The supplier or the retailer may have some defenses, so we cannot generalize. But according to the law, both can be subject to regulation. Let me ask one more question. It's important that we do proper public education, because some people may import products from the mainland without knowing a lot about the products, and then resell those products. Can we conduct some study to see if the mainland has similar requirements regulating products and toys for children under 4? And what are their limits on the pallets? Do they have similar laws, and are they on par with ours? We haven't conducted any study like this. Basically, we follow the practice in Europe, the US, and Canada. But all these countries that we have referred to uphold similar principles. And that is, we are only regulating products used locally. We do not regulate products to be exported. There are many requirements on children's products and toys on the mainland, but whether there are specific laws regulating the use of pallets, we have to check. But such regulation, if any, would only be for locally consumed products. The C&E Department and the Consumer Council may need to look into proper ways to publicize the new law and the regulatory regime, the relevant requirements and limits, so that importers and suppliers will not violate the law inadvertently. But maybe their study should look into other things, such as how to be a smart user. For example, an iPhone is not a toy, and the consumer shouldn't ask or let a child use it as a toy. And also, when someone buys a product, attention must be paid to the origin, and also whether it can be safely or lawfully be used in Hong Kong. I don't think I have got an answer for my question. I was asking whether there are comparable laws on the mainland, and do they adopt similar or same standards? Maybe I can venture a reply here. And Alice, you can supplement if you like. Our laws on toys in Hong Kong make sure that we comply with ASTM and EN71. And we have a set of Hong Kong standards, EN71 and ASTM, set up together with the toy manufacturers. And any toys that are to be sold in Hong Kong have to comply with this set of Hong Kong standards. Where they are manufactured is irrelevant. It's EN71 for Europe and ASTM for US. If we want to sell products on the mainland, we have to comply with mainland requirements. And products manufactured in Hong Kong, if they are to be sold in Hong Kong, they will have to comply with our laws. I think the business sector understand this fully. Of course, it's a different question if we are talking about parallel goods traders. So that's my understanding. Would you like to supplement, Alice? Chairman, your understanding is entirely correct. We set up a standards to enable our law enforcement agencies to enforce the law, and that is any children's product imported into Hong Kong for local use will have to comply with the requirements on the use of fellers wherever they are manufactured.
If I understand Mr. Wong correctly, he is asking what if the person purchases the product online for self-use? Well, as a consumer, if you order a product from other jurisdictions and that is not related to the sales in Hong Kong, then the consumer has to protect himself. Perhaps we should do more safety publicity. If Dr. Wong still wants to know whether or not the mainland has similar regulation on toys and children's products, we'll dig out those information. Well, Mr. Chairman, the information is very important. Probably the mainland does not have similar legislations, but such a protection regime is important. If all toys from the mainland do not satisfy Hong Kong's requirements, then all those products should not be imported into Hong Kong. I believe I've already answered your question. The mainland does have standards for products imported into Hong Kong. They have to satisfy Hong Kong laws. The Customs and Excise Department does have a checklist. As far as I understand, the C&E Department will do random checks. It's not true that they won't do anything. Perhaps the Customs and Excise Department can provide an answer. But I can tell you the mainland does have standards for products and toys to be imported into Hong Kong. If you apply for such products to be imported into Hong Kong, you have to satisfy the laws of Hong Kong. Otherwise, you won't be able to lawfully import those products into Hong Kong. I understand what you are saying. If they have similar laws, I'd like to know whether their regulation of phthalates is the same as that of ours. Then we can ensure that such products are safe when they're imported into Hong Kong. But if you tell me that the mainland does not have similar regulation on phthalates for children under the age of 4, then it will be different. Well, perhaps the administration can give us a reply later. Mr. Wong Ting Kwong, I'd like the Bureau to clarify whether our laws target only the mainland or the whole world, because some of our members repeatedly only mention mainland China or mainland. Well, all products imported into Hong Kong have to satisfy the laws of Hong Kong. All products from anywhere in the world. Alice, please make this point clear. Well, all toys and relevant children's products imported into Hong Kong are covered by laws, be they from Turkey, Singapore, Taiwan, or mainland. Our laws will apply. Just now, Dr. Helena Wong requested the Bureau to give us the mainland standards in writing. That is, whether or not they have statutory regulation. For other jurisdictions in the world, given Dr. Wong's logic, then for Hong Kong citizens, apart from considering mainland products, as she mentioned, is it that we don't need to know the regulatory regimes of other jurisdictions? Perhaps we should also ask the Bureau to tell us what other jurisdictions don't have a similar regulatory regimes, such that we can caution our consumers that they should not just pay attention to mainland products, but also products of other jurisdictions. Well, I think the issue is very clear. Whether or not the question has been asked, in law, there are very clear guidelines. And then in reality, most toys in the world are manufactured on the mainland. So mainland toys must satisfy the standards of Europe and America. Well, let's come back to the sales laws of Hong Kong. All toys sold in Hong Kong must satisfy Hong Kong standards, whether or not they're from the United States of America, the European Union, or the People's Republic of China. So we don't have to handle each and every jurisdiction. Just now I made it very clear that EU has its own standards, the USA has its own standards, China has its own standards. On the issue of phthalates, perhaps Alice can provide us with information. The EU and US standards are the standards that we're adopting here. Alice has made that point very clear. Mr. Chairman, as you said, all products imported into Hong Kong have to satisfy our laws. For the mainland, as they want to do business, they have to satisfy the European and American standards. We're very clear about that. The question is the logic and mindset of some of our members targets in particular the mainland. That's why I asked that question. Mr. Chairman, well, queue up again, please. Dr. Low Wai Kwok. Thank you, Chairman. In fact, Chairman, you've already spoken my mind just now. China is the biggest toy manufacturer in the world. In today's papers, information about Australia, New Zealand, USA, European countries, etc. have been set out. Whether or not you buy such products overseas or in the toy shops of Hong Kong, you can see that many famous foreign brands are actually produced on the mainland. The products are made in China. So they have to satisfy the European and American standards. Internationally, even though these standards are not totally identical, they're similar. And in the pieces of legislation we're scrutinizing now, we're actually adopting the practice of the European and American countries. Otherwise, parents will not find it safe to buy toys for their children. So parents can rest assured that our products are safe. Of course, if our colleagues want to have a deeper understanding of the standards on the mainland, by all means, provide them with information. But I think Hong Kong laws are not particularly harsh on any particular jurisdiction. So it's not necessary for us to be particularly worried about certain jurisdictions. The reality is that China is the biggest toy manufacturer in the world. In particular, their exported products have to satisfy many world standards. Dr. Helena Wong, well, I think Dr. Low Wai Kwok understands my logic, but the other colleague, Mr. Wong Ting Kwong, does not understand my logic. I don't want to target any particular jurisdiction. I'm only talking about facts. Number one, sales are beyond boundaries. Products can be imported from anywhere in the world. For toys, probably most of them are manufactured on the mainland. So when we scrutinize our laws, we should understand the situation in China. We have frequent exchanges with the mainland. Well, people may be carrying goods and products into Hong Kong. For example, those people under the individual visitor scheme. Now, these laws are not just for any particular party. It's for the whole general public of Hong Kong. China is by our side. If we're told that their regulatory regimes are very strict, then we'll feel comfortable. Mr. Wong Ting Kwong asked whether we should know the standards of European and American jurisdictions as well. Well, if the government wants to work harder, by all means, they can provide us with checklists for European and American jurisdictions as well. Well, let us come back to our work today. Our work is to scrutinize the proposed amendments. So we have to look at the actual circumstances of Hong Kong. Toys imported into Hong Kong come from all over the world. We have several common standards at the moment. If a certain member is concerned about the standards of a particular jurisdiction, I've already asked Alice just now to provide us in writing, to provide us with such information in writing. We have to make sure that we abide by the law. In this scrutiny exercise, well, you can say that some people do that, other people do that. I believe law-abiding businessmen will abide by the law. So we have to handle our documents and papers in that way. As for conspiracy theories, different people raise different comments day after day. So let's come back to the scrutiny exercise. That is how to handle products sold in Hong Kong. In my opinion, the government and our legal advisor have just now provided reasonable responses to our members. So on those few aspects, if there are no further comments, let's continue. Alice? We're now on LN 18. That is to repeal the old provision. That is the Toys and Children's Product Safety Regulation Repeal Regulation. That's the 424B that we mentioned. For the same date of commencement, the 424B will be repealed. And then LN 19, that is the commencement date. The commencement date of the amendment ordinance. On the same day, the amendment ordinance will take effect and the old 424B will be repealed. So it's also the 1st of July this year. Yes, the same. The 1st of July this year. Any other questions? If not, we've finished clause by clause scrutiny. We have to arrange the date of the next meeting. Last time we checked the dates. Next time we'll receive deputations and listen to their views. They've already signed up. That will be on the 21st of March, Friday, from 4:30 p.m. to 6:30 p.m. We'll then invite the relevant government officials to attend. Any questions? And then legislative timetable. We intend to, at the council meeting on the 19th of March, apply for an extension of the scrutiny period to the 9th of April. So the expiry date of scrutiny will be the 9th of April, and the deadline for submitting amendments will be the 1st of April. We need 5 full working days in advance. Our report to the House Committee, our work, that will be on the 28th of March. Any other business? Dr. Helena Wong? Mr. Chairman, the next meeting will be held on the 21st of March. Well, the electrical meeting on the 19th of March may last till Thursday and Friday. Mr. Chairman, a notice has been issued. That is, if necessary, the electrical meeting may be resumed at 3:30 p.m. on the 21st of March. If that is to happen, our meeting will be affected. We've actually worked out with the chairman an alternative date, that is the 24th of March, Monday, at 9 a.m. So, we'll closely monitor the progress of that electrical meeting to see whether we need to change our meeting date to the morning of the 24th of March. So it is possible that we'll meet at 9 a.m. on the 24th of March. Well, last time we fixed a date, but we now know that the electrical meeting of the 19th of March will be long, but we don't yet know the finishing time of that meeting. As the clerk told us just now, we will inform members because we have to inform the deputations as well. So we have marked another time slot for that meeting, an alternative time slot. We'll inform members as soon as possible. So, if there's no other business, meeting adjourned. Thank you.